Hello, my name is Patra Alinda, a legal officer at Judicial Service Commission, and you're welcome to this YouTube channel, the Judicial Service Commission Uganda. Just to remind you, Judicial Service Commission is a commission established by the 1995 Constitution of Uganda as amended under Article 146, and one of its mandates under Article 148, where this YouTube channel comes from or is derived from, is to prepare and implement programs for the education of and dissemination of information to the public on law and administration of justice. So, basing on the mandate of the Judicial Service Commission as per the 1995 Constitution, this YouTube channel was created to be able to disseminate information to the public, to you, our viewers, on law and administration of justice. Today, we will be discussing succession law in Uganda. Now, succession law is quite an interesting topic. We've had so many people, in a way, have a pinch of it. And while succession law, if there is no understanding of it, then administration of justice may not be seen to be done. So we need to know, what is succession law? This is the law that governs inheritance of estates of the deceased. We have tested succession and intestate succession in Uganda. Tested succession is where an estate is administered according to the will of the deceased. And intestate succession is where an estate is administered where there is no will. Today we shall be looking at tested succession, and we will be looking at a very important topic under tested succession called wills. Every day in our everyday lives, we've interacted or heard of, this person has passed on. Was there a will? What happens to the family? What happens to his or her estate? What is a will anyway? So today we shall be looking at what a will is, what are the main things that you must note before you prepare this will, what should be in your will to be a valid document considered in the courts of law, who makes a will, what are the things that should be in the will, who benefits from the will. All these we shall be able to discuss today in our session. So, to start away, what is a will? A will is the desire or expressions of a living person on the things that they want to be done to their estate once they have died or upon their death. That means any person, a woman, a man, can be able to make a will. What are the most important things to note then? That if a will is something that pronounces or expresses the desires of this person upon their death, then what must they consider before they prepare a will? Because these things will help you to have a valid will, or if not followed, you may find yourself having an invalid will which may not be recognized. So first of all, you must be an adult. According to the laws of Uganda, an adult person is someone above 18 years. So you must be above 18 years of age. Secondly, you must be of sound mind. What do we mean when we say you're a person of sound mind? You're a person who is not sick. You're not mentally sick. You're healthy, and you can understand what you are saying, what you are writing. Then you are a person of sound mind. That means that if you are under the control of someone to make this will, then also it will not be recognized. You must be free from any influence or control of any person. For example, someone puts you on gunpoint and says, make this will, I'm going to kill you, make this will. That will not be considered. Or you make this will because you are under the influence of drugs or alcohol. All those things will not be considered, that will be put under that said will. You must be free from the influence of drugs or alcohol. Someone may ask themselves, how about if someone is physically impaired or has speech impairment or visual impairment or hearing impairment? They can still make a will as long as they are sound at the time they are able to put down this will. Remember, the will is the document that expresses your desires upon your death, how you want your estate to be dealt with upon your death. How about if someone is mentally ill and they have an estate and they also have the desires on how this estate should be managed upon their death. A mental illness person or a person who has mental illness can be able to prepare a will at an interval when they are of sound mind. That interval when they are of sound mind, they are said to be able, they have the capacity to prepare the said will. So now those are the things that you must consider before you're making this will. Am I 18 years of age and above? Am I of sound mind? Am I free from any influence or control, maybe person or drugs or intoxicants, all those things, you must consider them and then be able to acknowledge that right now I can be able to make a will. Secondly, we must consider the property that you're going to put in. Is this property, does it belong to you? Is it under your name? Do you have proof? For example, if it is land, do you have a certificate of title in your name? If it is joint ownership, then that said property does not belong to you. Is it future property, for example, pension, NSSF? They must all be registered in your name. And usually someone will tell you, how about if you make a will and maybe 5 years from now you purchase more property? There is another document legally recognized called a codicil. A codicil is a document that amplifies, subtracts, or adds to a will, and it is also considered as being part of a will. So you can make your will. Once you add more property, you go back and amend. That will be considered as a codicil and will be considered as part of being a will. So what property do you have? Is it livestock? If it is livestock, is it yours or you share it with another person? If you share it with another person, then that cannot be included in your will. So we are going to now go ahead and look at what are the contents that make up a will after looking at the main things to note before you make this will. What are the main contents of a will? What should your will look like? If you write down a will, feel free to write it down in the language that you understand best. Feel free to make it in any template that you understand best. But what are the contents of this will? First of all, this will must be dated. When did you make this will? Don't just say March. March when? March 2024. March 2024. It's best to say 20th March 2024 or 20th September 2025 so that whoever reads this will knows that this person made this will on such and such a date. It must have the name of the maker. The name recognized according to the national identification card. If your name is Alinda Pacha and you just write Pacha, then it will not be recognized in the laws of Uganda. Who is your spouse? The name of your spouse. If you have one or two spouses, you should be able to write them down. And the spouse is defined under the succession laws of Uganda. This is a person you are married to or who your husband or wife according to the laws of Uganda. Were you able to conduct a church marriage or a civil marriage or a customary marriage or an Islamic marriage? Do you have a certificate to prove that actually this person you are their spouse? Then the name of the beneficiaries. How many beneficiaries do you have? Are they dependent beneficiaries? Are they your children? Are they relatives? You must be able to clearly outline which dependents they are. If they are your children, if they are your relatives, if they are your cousins. And please note that even a child born out, your child who is not a child of your spouse is your beneficiary. Then another thing you need to look out for, uh, again, uh, who is going to be an executor of this will. An executor is someone who is going to implement the said will. The person must be of sound mind. They must equally be above 18 years. Then beneficiaries should not be able to be an executor. An executor should be an independent person who is not a beneficiary to the estate or to your estate that is being put in this will. Then this will must be signed by you, and also you must have at least two witnesses who should sign the said will, and they should have their name on each page with a signature on each page and the date on each page, so that they can be able to recognize that actually this person made a will. Otherwise, if you have a will but it is not witnessed by anyone, it shall not be considered valid. If you go to your sitting room and make a will and keep it without it being witnessed by at least two people, that means they should minimum they should be two people. Three people, well and good. Four people, fine, but they cannot be one person. And these people must not just sign, they must sign, write their full name and the date on which they witnessed the said will. Now, we need to know also, again, like we said, the property that you have put, make sure that it is clearly stated, especially land. Land is very vital in administration of justice. If you have land in Kabale district, for example, are you just going to say land at Kabale district? You should be able to say land registered as plot this, block this parish, this sub-county, and in this district, registered in your names. You must also attach or have copies of the certificate of title to prove that this said land actually, at the time you prepared or wrote this will, belonged to you. Now, how about in circumstances where this will is there but it has no beneficiaries? What happens upon your demise or upon your death? The Administrator General shall be able to first give priority to beneficiaries because they are the ones who should be able to benefit from the said estate. While you have made your will and you're saying these are the desires of how my estate should be dealt with upon my death, the beneficiaries should have the first priority in sharing or in having a share in your estate. So if you do not put your beneficiaries, then the Administrator General shall be able to help in administering this estate, ensure that the beneficiaries have attained justice by getting a share on the said estate. Otherwise, please, let's make the will so that we can be able to have administration of justice, both in succession laws and even cuts across under land justice. Because even today we've seen issues from land usually coming from families because there was no will, there was nothing to be able to implement the desires and wishes of the deceased. So let's prepare our wills when we can, and we can always amplify them, subtract from them, or add from them using a codicil. Another thing you may want to ask yourself, so I've made this will, where can it be kept? You can keep this will, first of all, with a lawyer that you trust. If you do not have a lawyer, you can keep it with one of your witnesses. We already said that we have at least two witnesses. Keep the will with these two witnesses. Keep another copy with your bank. If you have a bank where you have a bank account, keep your will there so that upon your death, they can be able to bring out this will and implement your desires upon your estate as you wished. Otherwise, thank you so much for watching. I hope we learned one or two things from this session. In case you want us to talk about another topic, please feel free to comment in our comment section. Also follow us on our social media platforms like X, formerly Twitter, Judicial Service Commission. We usually upload programs on law and administration of justice, and we look forward to you utilizing them and learning one or two things. And thank you so much for watching. Bye.